Okay, hi guys. So today we're gonna start with our very first topic, which is concept and history of the company. Now, in this topic, we're gonna cover these subtopics. So, firstly, we wanna talk about some forms of business organization. So this you must have read in your class 11th or 12th. The what are the types of business organization? So we're gonna talk briefly about that. Then we're gonna move on to the issues with these type of business organizations. So what is the practical issues that the owners or the partners faces with while running these kind of business organizations? Then we're gonna talk about the concept of company. So basically, we're gonna talk about how did this term company was derived. Then we're going to talk about the modern history of the businesses. So from 11th to 13th century, what were the locus of the business and how it got evolved. Then we're going to talk about the how the Companies Act was formulated and how it reached to India, and how when did the Indian government or let's say Indian Parliament pass the Companies Act. Then after this, you'll be having some multiple choice questions that you need to answer and clear this particular topic. Now, firstly, let's just move on to this slide. As you can see over here, that there is person A, and he states the fact that he's tired of working for someone else. That means that he was employed somewhere else, and now he would like to start his own salon. So, for the purpose that he's willing to start his own salon, that means this is a kind of business that he's want to venture in, and he's ready to put in the capital of rupees 5 lakh rupee. So this is the sole proprietorship we are talking about, because he wants to own the salon and he wants to just infuse the capital by himself. Now we're gonna move further. So they let's just presume that it was a good venture, and it went like this. So for in the first year, by the end of first year of the operations, he had the loss of 2 lakh rupee. Then from the second year, he gained, or he attained the profits of 20,000 rupee. Then third year 50,000, fourth year 1 lakh, and fifth year 1 lakh. Now, this operations is ongoing, and he may continue to earn profits, but there is a limit to it. So now, if he is willing to expand, then he might face issues with regard to the expansion. So, firstly, the issues with the sole proprietorship is it's very difficult to raise the capital. So, if you have studied the ways to raise the capitals, there are only two ways to raise the capital with the business organizations. So either you give your equity, that means you dilute your shareholding, or you may go for the loan. So you may just take a debt from the banks and finance yourself. So while in sole proprietorship, the both are very difficult. So in the first case, you will not be willing to dilute your equity. That means because you are having the 100% shareholding of the of the proprietorship, and whereby if you're gonna dilute your shareholding, that means you're giving the shares to someone else. So all these hard work that you have done in the last 5 years, 10 years probably, you want to give some part to the another person who's just giving you the money in return. Then in that, so you need to have a credibility with the bank or the financial institution that they can give you, and for the purpose you may need to give the collateral also. So, collateral is not merely can given on the basis of the goodwill that you have. So you need to have some fixed asset for that matter to give the collateral. So it's not so easy to raise the debt through equity, or raise the finance through equity or debt. So in practicality, it is quite difficult. It's not impossible, but it's quite difficult. Then the sole proprietor is having unlimited liability. So that means that my liability is not limited to the extent of the share capital that I have infused. So like in the example, we have seen that Mr. E has infused 5 lakh of capital for starting his own salon. Now that means that if he takes a loan from the bank, let's just presume that he takes around 10 lakh loan from the bank, and then he defaults on the payment of the interest and the principal. Now the point is that bank will not only take away his sole proprietorship, which is the salon business, rather they can also reach out to his personal property. So his personal property could be his car, his gold, or his own residential property or commercial properties. So that can also be touched upon. So there is no limit to it. So the sole proprietor is having unlimited liability. That means his own personal assets are at stake in case of any default. Now, the third one will be that there is a heavy burden of decision making. So that means that the person who is running the sole proprietorship, he's in entire control of the business, and consequence of this is that he is the only person who gonna make decision in regard to any operational or any financial decision. He's the one who needs to take. So we can't able to consult with anyone else who might be having some greater stakes in this particular business venture. So these are some very pertinent cons of starting this sole proprietorship. And thus, if we're gonna go further now, just see that how things can turn up. So uh, if Mr. A is willing to expand this particular sole proprietorship, what the saloon that he has opened. So in this case, if he's not willing to take up the loan, because generally our tendency is that we don't go for the loan so easily, our possibility will be that we're gonna infuse more capital by ourselves. So in this case, if he's in a fixed to actually how to finance or how to finance his expansion, and his friends get to know about the fact that this business is quite profitable because it has shown the consistent return in past 4 years, as you can see from here. So in this case, B seems interested. B may be his friend or cousin or sibling, whatever we can take the relationship maybe. Now, so B is willing to invest in this particular business by way of infusing more capital and by way of facilitating the expansion. But yeah, as you can see over here, that he's asking for more. He's asking for the 50% share of the profits. So that means in the upcoming future, whatever the profits that this particular salon will attain, the 50% will go into the account of Mr. B. So that means that's a dilution of share capital that we have just talked about, which is the equity part of financing. So he's asking for that he needs to own 50% of the shares of this particular sole proprietorship. Now in this case, if they're gonna go further, I mean they're gonna be consensus on this, and Mr. A doesn't have problem with that, because if business gonna expand, then the profit will expand. So now in this case, we can actually agree to infuse more capital. But the point is, now this is not a sole proprietorship. Now this business ownership is transformed into something else, because now there are two people who are owning some shares in this particular venture. So now in this case, there might be some issues in future, because when money is involved, then there's a possibility of some probable issues. So now they need to look for some law probably which can facilitate their arrangement, and which can actually pen down their arrangement, so that in case of any disputes or controversies, they have something to look for. So now the only other form of business that comes into consideration is the partnership. So any dispute, any controversies, any regulation with respect to owning the share in particular business venture has been uh, taken care by the Indian Partnership Act 1932. So this is this substantive as a procedural act, which gives us the idea about how the partnership can be built up, and how to actually arrange, how to do the arrangement of such partnerships. So so now this is not a sole proprietorship anymore. That this has transformed into the partnership now. So as you can see that earlier it was just a salon. Now since A and B have partnered into this venture, and they have infused some capital, so now the terminology has been changed to AB and partners. And this business, although the business core business is same, which is salon, but the name has changed actually, and it has been now regulated by the Indian Partnership Act. Now although this seems to be a good venture, because the motive of expanding your operations has increased, and there is another person to actually help you with the decision making. But there are some other disadvantages of the partnership firm as well. So we're gonna check out the disadvantages of the partnership firm. Okay, now first one being the unlimited liability. So as it was there in the sole proprietorship, the unlimited liability is consistent with the partnership as well. So even if it's been regulated by the law, but the law clearly says that when the partners get into such agreements, their liability is unlimited. So if they're gonna take up any loan for that matter from the bank to expand their operations, to finance their operations, Now, then also the bank or the financial institution or the debtor, so the creditor can actually reach out to their personal properties. So there is no bar to it. There is no extent to the limit of the capital that they have infused. So that means the liability still remains unlimited, which is a major drawback in the sense of the partnership, uh, the arrangement of partnership. Then there is a there are some provision of the compulsory dissolution. So in case any one of them, A and B, dies, then the partnership firm needs to be dissolved. So there is no other way that the partnership can continue. So this is very uncertain. That makes the business venture very uncertain, because the, 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 the death is not in your hands. So merely on the death of one or the other partner, the firm needs to get dissolved. Then there is no relaxation on the tax obligations. So taxes are same. There is nothing as such that the partners can actually take a benefit of the tax obligations. So there is no benefit or no relief of lowering down your tax obligation. Then it's again very difficult to raise capital by way of equity now. So again, if there are two partners already, they would not like to dilute their shareholding further, and they would not like to actually involve the third person, the fourth person, to venture in this particular partnership. So by way of equity, then again it's very difficult to actually raise the capital, and then the only way which has been left is to go for the debt. But the problem with debt, the raising finance through debt, is that your liability is unlimited. Now so there is a if even if you can say that both the partners are actually convinced to actually raise the capital through the dilution of shareholding, then there is also a limit to the partners. So if you're going to expand your business in various continents, in various countries, and you would like to have more capital, then there is an extent that has been created by the company's miscellaneous rules 2014, that the maximum number of partners can be only 50. So you can't have more than 50 partners in any of the partnership firm. So that's the extent that also can be a demerit of the partnership firm. Now, probable issues, all of these probable issues have been answered by the Companies Act 2013. So, so that's a good addressal, and that's another form which has been created, that the business and the entrepreneurs or the people who are willing to do business can start their own business formation. So all of these issues can be taken care of by the Companies Act 2013. So now we're going to talk about the concept of company. That what is the company? How do you define company? Now, firstly, there is no, let's just not define the company in our own language, because that has been later defined by the Companies Act 2013. But the first point is, how did this word came into existence? So company is basically that's a mixture of the two Latin words. So the Latin words were cum and panis. Now that means you gonna eat together, or having a meal together, or having a bread together. So if you you would have heard the terms come pan. Come pan means eating the bread together, or eating together. Now, why did this word came into existence was that a lot of people in the earlier history, early era, whenever they used to have bread together, meals together, they used to talk about the business, which is there in the present scenario as well. Whenever we are closely sitting together, we usually talk about business, or people with the same orientation of mind usually talk about business. So this is where the company word came into existence, that you talk about the business or the ventures when you are sitting together and having a meal. So that's the origin of this particular term. Now let's just talk about the modern history. So as I said earlier, that we're going to talk about the what were the happenings in the 11th to between the 11th to 13th century. How did the business organization were evolving? So firstly, the main trade which has been taken over in the entire world was concentrated in the British Island. So they were British merchants. Merchants, as the name suggests, these are the people who trade or buy, sell, or trade goods and services. So these British merchants were located in the were located in the England, and they were trading in some certain category of goods, let's say just spices, or probably the food grains, the cotton or silk, or whatever the different kind of products that were available at point of time. So these British merchants were having that's a huge group that the merchants, the total merchants were there, and the huge groups were divided into few associations. So few associations were based on the type of products that the merchants are dealing with. So let's say that's there are 50 merchants, and 10 of them are dealing with the cotton, or trade supply, or a purchase of cotton. So these 10 people will form a merchant guild. So this is particularly a guild is the association is informed, or probably it can be divided as per the cities as well. So let's say that the 10 merchants are from the city of Manchester. So these 10 merchants will form a merchant guild of Manchester, and they may include the merchants of various kinds. Let's say the people who are dealing with spices, or let's say silk, or any other substance whatsoever. So these are the small association based upon the cities or the type of goods that they are dealing with. So these merchant guilds were duly recognized, and they were given the status of guilds as per whatever they are selling, the categories of good probably, or the type of dealings that they're into. So they can be, as me, that there are wholesalers, there are retailers, there are distributors. So depending upon that as well, so there could be 5 people who are distributors of the cotton in some city. So that's the merchant guild. Now there could be 10 people who are the retailers of the spices, so they can have the merchant guild or the association. So these are the merchant guild, duly recognized and bifurcated as per these particular divisions. Now, these guilds obtained the charter from the crown, mainly actually to give them the monopoly in the trade. So, the charter means that, I mean, that's the license to actually operate in some market. So, they have obtained the royal charter. Royal charter has been granted by the Queen. So, and this charter means that they are having the due monopoly to actually trade in some certain category of goods or certain market. So let's just presume that there are 10 people, the 10 people who are dealing with the cotton, they are giving the due charter to actually uh, deal with this particular segment, and there are no other merchant can enter in this particular segment. So these charters have been created or been granted by the Queen, and then the monopoly has been created. So it's very difficult to actually for the new merchant to actually get into this particular already created monopoly. Now, the merchant guilds, by its own virtue, had been divided into two separate um, uh, forms. So, firstly, is the commandas and societas. So, commanda was the form of partnership. Then, as we've seen that what is the partnership, we have having some idea of it. So, this is a kind of partnership wherein the financer is the person who has infused much of the capital, was a sleeping partner. Now, sleeping partner means that he was not active in making any decisions whatsoever. So, he or she just have put in the capital, but he's not actively involved in the operational activities of the business venture. And then he was having limited liability. So unlike the our particular today's form of business partnerships, this person who has actually financed the commanders was having the limited liability because he was not actively involved in the operations. And the other liability was actually borne by the working partners, because that makes sense, because the people who are making decisions, they should be liable for their actions. So this is very prominent type of merchant guild which was formed during that times. Then there was societas were very very much similar to that of today's kind of partnerships. So it was a type of partnership wherein all the members took active part in the management, like in today, and they all had the unlimited liability. So there was no concept of sleeping partner. So everyone who has put in the capital, they have actually been very active in making the decisions, and they had the unlimited liability. So these were the two type of merchant guilds which were existing at that point of time. Then from 14th to 16th century, we saw the trend of the companies coming into existence. Now, during this particular time, the merchants first were the first ones who started using these terms, companies. That means that's a Latin term, as a type of association for trading overseas. Now, it was fine till the point that when they were operating within the territorial limits of the England, but when they wanted to trade outside of the England, then they gave some name to these particular associations. Now, these names were based on the term used as the companies. So let's just say the people who are dealing with the cotton, they might have given the name of cotton company, or the people who are dealing with the spices, they might have named this particular merchant guild as the spices company. So this company term is been used during the 14th century times. Now, in the 16th century, so the later part of the 16th century, the royal charter has been given to these particular companies which have been operated by the British merchants to actually uh, they had a monopoly of trade over certain territory. Now, so the monopoly within the England territory have been actually extended to the monopoly in the overseas territory also. So let's just presume that there is a company A which is dealing in cotton. They've been given the monopoly of trade in the Asia. So there can't be no other company which can actually trade the cotton in the Asia. So again, the charter has actually facilitated the monopoly of trade to these British merchants, and they can actually uh, take entire control of the trade of cotton or any product they're dealing with in uh, certain territory. Now, similarly, by going by this fact, during this particular century, the East India Company came into existence, and this particular company was been given the royal charter by the Queen to have a monopoly over the trade in India. Now, as I've said that there's a certain monopoly in certain regions. Now, East India Company, by the name itself, has given some due privilege to actually conduct some trade in the territorial limits of the India. Now, uh, so there were some characteristics of the East Indian Company at that point of time. It says that its member could carry on trade individually and had to subscribe to the joint fund or common stock of the company. After the voyage, the profits made together were being subscribed amount were divided among the members. So all the members, they need not to actually just deal only in certain category of goods. Now, these they were the part of the East India Company, but when they go to the India, they can deal in any product or services. So they can deal with any, let's say, just silk or probably iron or probably ore or any mineral or any spice, and whatever they're gonna deal with, they're gonna earn some profits, and all the profits were being earned in the name of East India Company. And when they're gonna come back to the England after their voyage ends, then these profits will be divided in all of these members. So this is how it worked in there. And this is what the form the I mean the basis of operations over there. So this is very interesting because nowadays the company doesn't work like that, because the members have to be united in making a call of operations. But since there were no expertise in this at that particular era, all the members were having the due advantage to trade or to buy or supply any type of goods and services that they're uh, specialized into. So now East India Company and the other companies, they were at some point of time they were established with the permanent fixed capitals, and which were represented by the shares. Now again, the shares concept were being introduced, and the shares were freely saleable and transferable. So just in case if the one merchant is maybe wants to give the right of control of its membership of the in the company to his son, let's say. So he can freely sell the shares to the or transfer the shares in the name of son or probably any other person. So the shares were freely transferable, unlike the previous version wherein the other merchants cannot enter the market but by the way of shares or the issuing of shares, the other person can enter into market by just purchasing the shares from the existing merchant. Now, the assets of the companies were kept directly under the control of the governors or the directors. So this position have been created wherein all the assets which were acquired by the companies have been kept under the respective directors or under the control of respective directors. So these directors are having all the due fiduciary capacities. There is whenever the royal needs to, I mean, a royal queen needs to check what kind of assets the companies are. They don't need to go to every merchant. Rather, they're gonna go to the single point of contact, which is the directors or the governors. So this is the structure which has been evolved after in these kind of companies. Now, to see what was the basic modus operandi of the East India Company was. Now, East India Company was been granted the royal charter to deal with the tradings in India. So they were primarily focusing on trading the cotton, silk, and spices. So when they landed into the Indian territory, they were acquiring the cotton, they were acquiring the silk and spices at the lower prices, and they were selling these particular products in the Europe at a higher prices. So this is the modus operandi. You buy from the one price at the lower price, and you sell it at a higher price in some other region. So whatever the profits have been acquired, they have been kept as the funds of the East India Company and later used for the expansion. Now, when the trade were earlier, they were trading only with these particular products. Now, because of their will to expand their operations, the company was willing to set up their factory, and the first factory was been set up in the Hooghly. So Hooghly is in the east of India, and this factory is particularly was set up in the as a way of storage and the warehouse. Not It's not a factory to actually make or produce some goods and services, goods perhaps. So it's rather a storage factory or storage warehouse wherein whatever the goods have been purchased by all these merchants can be kept in one place. Now, what happened thereafter was that the East India Company, the officials of the East India Company, bribed the Mughal Empire at that point of time to actually uh, have the zamindari rights over the three villages. So, zamindari rights, what will happen with the zamindari rights? That whatever the goods have been produced in these three villages will belong to the East India Company. So, since the entire India was divided, been ruled by the Mughal empires, so that's what the right point of contact for the East India Company officials to actually go and bribe these officials and take a control of three villages only. First one being the Kalikata. So Kalikata is the older version, the older name of the Kolkata at the present time. So Kolkata, the right was been given to the East India Company, then Sultanati and Gobindpur. So whatever the production will happen in these villages will belong to the East India Company entirely, and whatever the products have been produced, they can be stored in the warehouse which has been purchased by the East India Company. Now, thereafter, the East India Company officials, since they were very aspiring and with the motive of expansion in the India, they persuaded Aurangzeb. So Aurangzeb was the head of I mean, he was the Mughal emperor. So they persuaded Aurangzeb to issue them the Farman. So Farman is again, it's kind of a royal charter or the royal order that which is having permission of trade. Now, permission of trade was fine, but they persuaded Aurangzeb to actually include the condition of duty-free trade in India. So that means that whatever has been traded, these merchants will not be asked to pay any duties to the to the Aurangzeb or the Mughal Empire. So that's a duty-free trade. Whatever you purchase, there is no duty. There are no taxes. Duty is basically the taxes which have been imposed on the trade of the goods and services. So this right is been given by the Aurangzeb. What were going in his mind, we can't talk about that. So this right is, I mean, this right by way of a clause in this particular farman is been given by Aurangzeb, and the East India Company was not giving any taxes to the Indian state of India. Then, although the main objective of the East India Company was to buy goods from India at a lower price and ship it back to the European continent at a higher price. But there were some corrupt officials within the East India Company. So corrupt officials means they were the members. Since every member is having the entire discretion to trade whatever product that they want to deal with. So there are some corrupt officials within the company who started the private trading. So what does that mean? That they used to buy some goods from the India from the territory of India, and they used to sell it at a higher price in Europe. Now, by just not disclosing it as a operations of East India Company, they are not supposed to pay any taxes to the royal government. So neither they were paying taxes to the Indian empire, the Mughal Empire, or neither they were paying because of the Farman issued by the Aurangzeb, and neither they were paying any taxes to the British government because of the fact that they are not disclosing these particular kind of trades. And there were no checks and balances created by the Royal Charter or through the Royal Charter. Now, because of the virtue of the fact that there were heavy loss of the or substantial loss faced by the tax by the experienced by the government of Britain or at that point of time, the Queen of Britain at that point of time, because there was a consistent decline in the taxes because a lot of other officials who are getting involved in the private trading rather than the trading by using the name of East India Company. So the the England passed their first act by way of regulating these particular companies, and the first act which has been passed was the Joint Stock Companies Act 1844. Sorry. Now, there were some major provisions in this. So, firstly, they made the registration compulsory along with the names of the members. Now, this regulation means that whatever members are there, their names will be entirely disclosed with all the other information there, the place of address, what products they're dealing with. So everything is been noted down now. Now, uh, so the transferability of the share is also been facilitated without the consent of the members. However, since the name of the members are disclosed by way of registration, so any new member then if the shares have been transferred to the new member, their names have also needs to be registered as per the mandatory registration. Then there's a creation of the register of the company's position. So the registrar will maintain how many companies exist, to what companies are giving the what companies are having the charter to operate in certain territory, and then the annual filing of return with the registrar made compulsory. So after making this particular position, that the annual filing of the returns means whatever has been dealt with during the financial year, they need to the every merchant needs to disclose it. Whatever the earnings were there, they need to disclose it and mention it down in their annual filings. And this filings needs to be uh, uh, placed with the register of company, which is directly under the control of royal government. So this is how it worked, that they were regulated now, and they were regulated as per the Companies Act 1844. Now, what was happening in India at that point of time? That after just after the 6 years down the line, when the British government passed the first act, the Indian government also, the not precisely the Indian government, no, they were the Britishers were in entire control of the Indian Parliament and the government functionaries. So they themselves also passed this particular act in the state of India also. So first act which came into the existence was the Joint Stock Companies Act 1850, and uh, so they introduced that the first feature, very distinct feature of the company, which is the separate legal entity. So this feature is being introduced now, and now the companies are no longer similar to the owners. So they have this separate artificial legal entity. Now thereafter, the Companies Act 1856 was introduced. So earlier in the previous act, which is 1850, there was nothing about the limited liability, which is the we have seen that foremost con of the uh, sole proprietorship and the partnership form of business organizations. So then the limited liability concept was been introduced, and but the this particular feature was not applicable in case of any banking or the financial institution companies, because they're primarily dealing with the finance or the transferring or and the transaction of finance, which are financial in nature. Then there was another amendment to this particular act, which is the new act which has been formulated, which is Companies Act 1866. And so the rules of incorporation and winding up has been formulated. So how can company start and how can company close down, that has been formulated. Then thereafter, 1882 was been formed, and which has been recast as for to bring it with the conformity with the English law. So English law has been um, forming at a very rapid pace, unlike the India. So they were having major good provisions in their relative companies act at that point of time. But to bring it with the consonance of the English law, the Companies Act 1882 was formed. So this is because again I'm repeating that the entire Englishmen were regulating the companies as well as the government functionary. So they passed this particular act to make it with the conformity of the English law. Now another new act was been passed in Indian Parliament, which is Companies Act 930, and which has been amended in later 4 years. So this is again as with the consonance of the amendments made in the English law, and looking at the present at that point of the present scenario of the Indian continent, how the companies were doing, and addressing the issues raised by the companies or experienced by the companies. Then the latest act, I mean the latest is Companies Act 2013, but before that we had the Companies Act 1956, which is all the provisions which have been incorporated, which have been amended in these particular previous provisions of the Companies Act. Previous versions of the Companies Act have been comprehensively incorporated in the Companies Act 1956. So all the previous have been taken into account for, which were actually practically possible to implement. So this has been taken into account, and the Companies Act 1956 was been passed in the Indian territory. Now 56 again was being amended in various years, but the only major provisions were been amended after the liberalization policy, which came in the year 1991. So before that, the Indian corporate sector was been predominantly uh, taken over by the government itself, and it was not privatized. So after 1991 when the LPG policy were been introduced, so the lot of new entrants were there, including the private players, and thus there was a very much need of actually liberating this particular Companies Act. Also, liberating means that there's a relaxation in the rules of procedural rules of forming the company or dissolving the company or regulating the company for that matter. So now after that, when there was an immense need of uh, actually bringing the law to comply with the latest practical approaches, the Companies Act 2013 was passed in the Indian Parliament on 29th of August 2013, and it consolidate all the provisions of the 1956 except few which are not uh, which was not feasible to take on over as per the practical present scenario, and new provisions were been added also. So 1956 were been repealed, and 2013 were been taken over, superseded uh, this particular uh, act. So this is how the Companies Act 2013 came into the force, and this is how the companies uh, have evolved, and the provision of the companies have evolved in India also. Now you're gonna face some multiple choice questions, and you need to clear it. So good luck for that. Thank you so much.